Hello, everybody. Welcome to part 2 of our webinar, Estate Planning for Physicians, Protection for You and Your Family. We're so glad to have you all here for the second webinar. So I would like to make some introductions on our presenters today. We have Todd Hudgins here. He is a CPA tax attorney, and he has his LLM in tax. And then we also have David Auer. He is our owner and founder of our firm. And then Bill Bennett, he specializes in financial architecture. And then lastly, myself, Angie O'Day, I'm the client success manager here. So just going quickly over our disclaimer, we want to let everyone know that everything we're discussing today is within the four corners of tax law. We will not be giving any information that stays outside of those boundaries. So our agenda today, it's going to be very exciting. First off, we're going to do a definition of estate planning. Second, we'll do why estate planning is important. Third, basic estate and asset protection planning. Fourth, advanced estate and asset protection planning. And lastly, we will open it up to Q&A and answering any questions you may have.
Great, Angie. Thanks for that. Thanks for that introduction. And thank you guys for joining us today. David, if you and Bill or Angie have things to say as we go through this, please just jump in there, because I know you guys have a lot of good information that you can share with our participants today as well. But I just wanted to start out by defining estate planning. And I know we hear a lot about estate planning, and sometimes it gets confusing as to what it really means. But this is how we like to define estate planning. It's really that you want to have a plan to control your property while you're alive. You want to take care of your loved ones and yourself if you become disabled. That's a big one, right? I mean, we could all suffer a disability. And you want to give what you have to who you want, when you want, and the way you want. And whenever possible, you want to save as much as you can on taxes, court costs, attorney fees, and other professional fees. Does everyone think that's a pretty good definition of estate planning? I think it's a pretty good definition. I know sometimes estate planning gets complicated, but it's really not that complicated. And you might ask, why is estate planning important? Well, estate planning is very important for all of us, right? Because if you don't have a plan, the state that you live in has a plan for you. And you might not like that plan. So if you don't have a plan, you can end up going through a thing called probate. And probate in my book is very bad because it's time consuming, expensive, and public. And on the expensive part, the probate fees can average anywhere between 3 and 8% of the gross value of your estate. So just do that math. That can be pretty high. If you die without a will, you can have some unintended beneficiaries as well. And that's what we call the laws of intestate succession. So you don't want to die without a will. I've had several instances where that's happened in my practice, and it's very sad to see when these unintended beneficiaries end up with your property. So if you do have a will, the will still will have to go through probate. Oftentimes people get confused and they say, well, I thought I had a will, and you're telling me that I'm still going to go through probate. And that's true. If you have a will and you die with assets in your own individual name, you're still going to go through the probate process. And then if you die without a will, you're going to be subject to what we refer to as intestate succession. And that's where you have these unintended beneficiaries that could end up with some of your assets. So the real way to avoid both probate and intestate succession is to use a fully funded revocable living trust. And so we're going to talk a lot about that today. But a fully funded revocable living trust, I think, David, you and Bill would probably agree that that's what we see most clients using in today's planning, right?
Well, especially those who have done planning. So unfortunately, a lot of our clients have, not gotten around to doing anything more than a basic will. And as they advance through life and have life events like getting married, having children, acquiring property, having life insurance, all of those things just increase the importance of moving from just having a will which then pushes all the control over to a court to decide how everything's distributed, to having a trust where all of the people named in the trust have control.
Yeah, very much so. And even if we see that people do have a plan, one of the big things that we see is they never update that plan. So a lot of people think that estate planning is just a one-time event, that I checked the box, I did my estate planning, I put my little binder on the shelf, and I never have to worry about it again until someone dies. But unfortunately, and David, you and Bill might agree with me, but that's really, your plan's probably not going to work if it's a one and done type situation. So you need to revisit your plan. You need to make sure that the people that you have named are correct in the plan, and that the plan controls all of your assets. Bill, you have anything you want to add to that, or?
Yeah, I think, I mean, one of the things that I know you'll go into a little bit further detail probably as we go through this webinar, but like you were talking about with updating the plan, right? Because I know when we put together the trust for the clients, then, we're going to have a pour over will. And so everything that's not mentioned in the trust specifically goes into the will. But again, if it's not mentioned specifically or named specifically with, who the beneficiary is, because it's just in that pour over will, then again, it goes into that and through that probate process. And so that's why it's so important to continually update your trust over time and your estate plan over time, especially as your assets grow over time, ensuring that you have minimal state inclusion into what your assets are. So
Yeah, that's good. Thanks. That's good for us to think about. And that kind of brings us to the next point, Bill, right? Taxes, two certainties in life, right? Death and taxes. And so the estate tax, as most people might know, is 40% on anything that's above your exemption amount. And currently that exemption amount is $13,610,000 per person, or $27,220,000 if you're married. One thing to note is that under current law, that exemption amount is scheduled to decrease to $5 million January 1, 2026. Now they're saying that will be indexed for inflation, so that could be somewhere in the neighborhood of $6 to $6.5 million. You guys might be familiar with the fact that you get a basis step up on all of your assets at your death. And so that means that the basis is stepped up to fair market value. So if you bought Apple at $10 and you die and it's worth $1,000, then your heirs can sell that Apple stock and have no capital gain. So sometimes it's good to hold appreciated assets until your death and take advantage of that step up in basis. We also have on here that currently the maximum capital gain tax is 20%, unless you're lucky enough to get hit with that 3.8% surcharge. So you could end up paying 23.8%.
And state income tax.
And state income tax. Very good. The next thing we're going to talk a little bit about is how important it is to title your property correctly. And the biggest thing with this, we talked a little bit about it already, but it's so important to make sure that your assets are actually controlled by your estate plan. And what I mean by that is to make sure that your house is owned by your trust. Make sure that your other assets are either owned by your trust or maybe controlled by your trust through a beneficiary designation. The one thing that you can't do is you can't ever move any of your retirement plans to your trust, or that would make everything taxable immediately. So make sure you don't do that. But do make sure that you look at all of your assets and make sure that they're owned or controlled by your trust in the form of ownership or a beneficiary designation. One asset that I've kind of dealt with here lately is cryptocurrency. And that seems to be a very interesting asset to make sure that you have that properly owned, to make sure that it's passed on to your heirs. David, have you or Bill had any experience with that?
Not yet. So how is that? I've heard I've encountered that there's restrictions on how you can own crypto, because we've had some difficulty where we wanted that to be inside of the name of of a business entity, and it had to be in the name of an individual.
Yeah, so I think that's a challenge, and I've seen that with at least with Coinbase, with a couple of my clients that have Coinbase accounts. So, and I really haven't found a good solution to that. So, kind of a challenging asset to deal with. And then some of my other clients have it on their own, have it in their own vault. That they have their own personal vault that they keep it in. So, just making sure that someone has access to that, right? If you get hit by the bus. So just important, I guess, to note that you go back and check at least every so often to make sure that your assets are properly owned. I did have a client that was an interesting situation too. He had gotten divorced and he still had his ex-wife on a life insurance policy, and then he got hit by the bus. So luckily, under state law, that got saved and didn't go to his ex-wife. But it's something, still you want to look at. We have several of the ways you can own property: fee simple, tenancy in common, joint tenancy, tenancy in the entirety, and community property. Let's move on just a little bit to talk to you about two examples of people that did do some good planning. I know you guys have all heard of Cornelius Vanderbilt. Cornelius, pretty amazing, but when he died, he left a fortune that would have been valued at $250 billion in today's dollars if he would have died today. He actually died in 1877, but if he died today, that amount of money that he left to his heirs would have been worth $250 billion. When the Vanderbilts gathered together at their family reunion in 1973, there was no millionaires left among the Vanderbilt family. So pretty amazing, right? That no one's left that had any substantial wealth. And you compare that to the Rothschild family, and the Rothschild family has managed to keep their wealth throughout the generations, and it's still, the house of Rothschild is still very much alive and well. So just good planning can go a long way. Cornelius's kids were very good at spending money and not very good at keeping it or making it. I think I read somewhere that they had around like 9 mansions on Madison Avenue, and by the time 1973, all those mansions had been sold. So no mansions left, all the property had been gone. So very sad too. And so a lot of these things can be prevented with good planning. Some of the things that we see people doing, and David, you and Bill might have some good examples as well, but and I've seen lots of situations where clients match either what their children report on their 1040 every year on their personal tax return, and so they give them some incentive to get out and make their own money. I understand that sometimes kids might go into some profession like a teacher or perhaps in a missionary that doesn't make a lot of money, but then you can always provide some type of floor that you give these kids. David, have you and Bill seen any kind of incentive type trust like that?
Yes, I have. And just to get a little background on the Vanderbilt versus Rothschild stories, which I think they're very powerful. In Vanderbilt's case, he was the wealthiest person in the world when he died, and he made his wealth in railroads, because that was obviously the big thing back then. And he gave about $2 million to a local university that obviously changed their name to Vanderbilt University, and then the rest of it he just gave outright to his wife, who then, when she died, gave it to their kids. So nothing was ever held in trust. It was just went direct from one heir to another. In Rothschild's situation, he was a banker by trade or by experience. And what he did with his family is he created what he referred to as a conceptual family bank. So in that family bank, what he had was 3 rules. And that the 3 rules were, or the first one was that if you were a member of the Rothschild family, you could borrow from the family bank, but you had to repay it as a condition. And so you could borrow the money to go start a business, to go to school, to invest in real estate. but at the end of the day, you had to pay it back. There was no outright distribution of an entitlement or a trust fund baby, that anybody in the Rothschild family had. The second part of that family bank was that every time you paid back the money, you were required to share your experience, both positive and negative, about what you learned through that doing that transaction with everyone in the family, both horizontally with siblings, cousins, and vertically with aunts and uncles and nieces and nephews, so that they would learn from your wisdom, and that collective wisdom would pass on down through the generations, which unfortunately, rarely ever happens. Every generation kind of has to relearn, making mistakes all over again. That's generally why wealth doesn't, last beyond 3 generations, like the proverb, shirt sleeves to shirt sleeves in 3 generations. The third requirement of the family bank was that everyone in the Rothschild family came back together every year to reaffirm the Rothschild family values. So, like you were mentioning, where some families may incentivize, their kids to work so that they'll match some of their W-2 income. Some will, incentivize them to go to education if that was one of the family values. All of those things are very, very important to pass on, not just the valuables that most people think about in a trust, but also the values that the generation that created that wealth stands for. So, just an interesting side story or backstory to those 2 gentlemen.
Oh, that's great.
I think that's great to share, David. I think when I look at the differences there, one of the main things that stands out to me is Rothschilds were creating good financial stewards and children and descendants that were financially literate, versus, like you said, on Vanderbilt's side, it's more or less just trust fund babies. And an opportunity where the question I always ask my clients is, do you know who your great great grandfather was? And for most people, they don't, right? But through proper estate planning, your great great grandchildren can know who you are, because you create a great estate plan that's going to pass down values, it's going to pass down literacy, and it's going to pass down stewardship. And when we have those things, that family wealth can continue to grow instead of erode over time.
That's good. That's good. One more thing about that story, and then we'll go on. We won't keep beating this Vanderbilt Rothschild story, I promise, guys. But one more thing is if you, David, did you or Bill hear this? That if you did not attend the family gathering every year, you got locked out of the family bank. So you had big incentive to go to the family gathering, right? So anyway, we'll move on. So let's talk about some basic estate and asset protection planning. Oftentimes, people ask me, they say, Todd, what documents do I really need to put in place? And so let's look at kind of what a foundational estate plan might look like. And, you can go the simple route that we talked about, and that would be a will. And maybe your will has some testamentary trust provisions for your minor children. But those trust provisions, those would be trusts that are created after your death, right? They're created through your will. So that plan would still have to go through the whole probate process that we discussed. Not a big fan of that. And then, you could go on the other side, you could go with a fully funded revocable trust. And that fully funded, remember funding just means that your trust controls your assets. And that control could be in the form of the trust owning the assets, or perhaps the trust is a beneficiary of some of the assets. And if you have a trust, I always get this question, if you have a trust, do you need a will? And yes, the answer is yes, you do need a will, but it's called a pour over will. And just think of that as a legal backstop in case we miss something. Okay, so the will says if we miss something, please pour it or dump it into my trust. You hope you're not using that will, because if you're using the will, it means you screwed up, right? We should have had everything owned or controlled by your trust while you were alive, and then we wouldn't have had to use the pour over will. But you still want to pour over will just in case something gets missed. Dave, Bill, any questions, comments on that?
Yeah, very, very important to make sure you always have the will with the trust. I've heard of the will described as a legal pooper scooper, because it comes along and scoops everything up that wasn't in the trust. But You don't, ideally, you don't want that. You want to make sure you're reviewing the trust on a regular basis, reviewing your assets, looking at how the assets are titled, because, when you're young and your net worth is growing, you're investing in things, and you don't always think, oh, I've got to make sure this is titled in the name of my trust. You do the simple thing, which is just have it in your name. But as long as you're reviewing that on a regular basis to make sure you've taken into account all the things that you've been acquiring.
No, that's good. Well, I think a lot of times we've mentioned this before, but lots of times people just don't do those reviews, right? They don't review. They just I think I saw a statistic one time. David, you probably know this, but you could probably tell me this statistic. But do you know how often people actually update their estate plans? It has a point. It has a point in it.
19.3 years.
Yeah, there you go. Wow, that's good. So every 19.3 years.
It's interesting because that's usually when somebody, the time between somebody having the first baby and usually the time when the first child gets married. So you all of a sudden see who your child's getting married to, and you think, I've got to update my trust to make sure I take care of that.
That's right. Well, and people, the crazy thing about that is in 19 years, just think of all the changes that people have had in their assets, in their family, potentially even in the law, right? And then you wonder why your plan doesn't work.
Well, and this is my personal feeling, is I just think this is a difficult topic for people to self-initiate, when they, usually people think about this when there's a major life event, or they've lost a family member, or they've maybe just inherited a large amount of money, and they've seen, who they inherited it from, the issues or problems that happened. So a lot of times it's just not something that, people just don't want to talk about, what's going to happen when they die. Everybody in that person's family wants that person to think about that, just so that they don't have to deal with it. Because really that, oftentimes if you don't deal with it, it just results in a huge crater, which I see all the time, where, somebody knows all the details, all the passwords, all that stuff, and they die and nobody else in the family knows. And sometimes it just results in a morbid scavenger hunt, where everybody's having to go find, look at tax returns or watch the mail, and it takes a really long time before things that could have been taken care of when somebody was alive, now you leave that to your family members, and that's the worst time, when they're going through a grieving process. Partly that depends on how much they inherit, but they go through this grieving process, and that's the last thing they want to be doing is having to go find everything.
Yeah, that's a great point. Well, and so we talked a little bit about the will-based plan. We talked about the fully funded revocable living trust. And if you have a fully funded revocable living trust, you also have a pour-over will, or as David referred to it, the legal pooper scooper. And then you're also going to have these ancillary documents. Okay, so everyone needs these ancillary documents, a durable power of attorney, and that's for finances and property. So you guys probably know what a durable power of attorney is, but that's the document I refer to sometimes is if you get hit by the bus and you don't die, then you need someone to be able to pay your bills, sign your tax returns, deal with your mail, all those types of things. You'd also need a healthcare power of attorney, so someone to make healthcare decisions for you if you can't make those on your own. And those are more decisions like course of treatment, administration of pain medication, keep me in my house or move me to a hospice, those types of decisions. And then you'll also have an advance directive, or what some people refer to as a living will. And that's where you really get to make your own decisions on, keep me hooked up or let me go. And depending on what your condition might be, if you're terminal, if you have an end-stage condition, or if you're persistently unconscious. So David, Bill, any thoughts on those other documents, those ancillary documents?
Well, I'll just say the significance of them. As somebody who dealt with this, as my mama was sick with brain cancer, and so as her mind went, and she did not have any kind of an estate plan in place, you find yourself having to go to the court system to be able to get the court's approval to start making some of these decisions. And all of it could have been avoided with some very basic estate planning. And and I think going back to what you said before, or David said, is it disrupts the grieving process. It does. And so, one of the things that I talk to my clients about is one of the most selfish things that you can do is not have an estate plan in place. Because if and when the time comes that you're going to force your spouse or children to start making decisions on your behalf that you could have made on your own. And so I strongly encourage and advise my clients to ensure that they have some kind of a base, even if it's a basic estate plan in place, to ensure that they're allowing their beneficiaries, their survivors, to actually go through the mourning and grieving process properly without being, having to come up with lots of different types of decisions that they have to make.
And the only thing I would add is, it also becomes, it's not an easy decision for everyone to decide who they want to name in these documents. Not only who would be the executor or personal representative of their will if there was a probate, but much more complicated, and it requires a lot more thinking as who you want to be your successor trustees. But the same thing goes with who has that financial acumen that you trust to to be that your agent in the financial power of attorney. Who's that caregiver that you want to be able to make, or you trust to be making healthcare related decisions, and then ultimately who do you want to be in charge of making end of life decisions. So those are very important roles, and not every family has individuals that are ideal for these roles. So you have to spend a lot of time thinking about it, and or combine individuals so that at least you have a little bit of a check and balance.
Yeah, that's a good point. And sometimes, Dave, do you or Bill see too where the right choice maybe isn't anyone in the family and perhaps is using some type of corporate trustee?
I see that. I'm not always a fan of going there first, because once you get something outside the control, unless you have somebody on the family, if you trust your bloodline, where they can fire and replace those third parties, because one of the big areas of growth in financial institutions is trust companies, and they get paid basically to hang on to money and manage it. So they're not necessarily going to be the most generous in making distributions. So sometimes just if you do go that route, just have somebody else that you trust to be able to replace that person if the family doesn't feel like they're doing their job in accordance with the trust document.
Right. No, that's good. Well, one other thing I might mention about these ancillary documents is that we do normally name a guardian for your children in the wills. And I know that was a big deal with my wife and I, is picking, who would raise your kids if you can't raise them. And even if you have disagreements with your spouse about who that person might be, it's better that you guys choose a person than having the state do it. So anyway,
or the family have to fight about it.
Yeah, very good. Yeah, or the family to have to fight. That's horrible too. There are often many special circumstances that might require special attention in a estate plan. And David and Bill, you guys might have seen some of these or have some good things to share with our audience as it relates to these special circumstances. And I know I have multiple clients that we need to deal with their closely held businesses in their estate plan. And that's a big deal, right? Because if you do have a business and you don't have any instructions on what happens to that business, when you go, it could be very hard for someone to pick it up, and potentially maybe even the value goes down very quickly. David, Bill, anything that you want to say about these areas?
Or all of them are potentially landmines. So I mean, it's if anyone approaches estate planning thinking they've got a simple situation, but they any of these issues on this list are involved or need to be addressed, and it's not necessarily as simple as you might think.
Yeah, that's very true. I mean, especially just a couple on here that I deal with a lot are parents with special needs children, definitely something you want to consider and when you're designing your plan, because if your plan's designed incorrectly, the way you leave those assets to a special needs child might disqualify them from any type of government funding that might be available. You know, what about remarriage protection? That's a big deal, right? If you're deceased and your spouse gets remarried, you want to make sure that your kids don't get cut out of the plan, that they still get something. I have a lot of clients that have properties in different states, potentially even in different countries. And so, you know, dealing with those types of issues in your estate plan can be a big deal too. If you don't have those properties dealt with, you can end up with probate proceedings in multiple states. And so that's no fun. We said probate's no fun. It's especially no fun when you get to do it multiple times.
And Todd, I think I just thought of another one that's not on this list that usually has to be addressed, and that is if you're expecting a significant inheritance from a family member. You know, you may have a simple estate now that doesn't need a lot of attention, but if you have that wealth dropped on you, you know, now all of a sudden it's your problem. So you know, anticipating what, especially if you're at an age where you've got elderly parents and they've got you know, they've got a significant amount of wealth that they're planning to give to you, you should at a minimum try to coordinate your estate planning with their estate planning, just to make sure you've taken everything into account.
You know, that's a good point. That's a good point. I think that's something that gets often overlooked too. But we're just going to go through an example too of a basic estate plan and just show you what that might look like. And here you can see that we have the individual or joint revocable living trust. And then we have the durable power of attorney, advanced directive or living will. We have the pour over will. You know, one thing we didn't mention earlier, but we have on this slide is a personal property memorandum. And oftentimes what we do is we assign all of your personal property to the trust. And so that would include things like your watches and your rings and your artwork and your guns. And then you can complete a personal property memorandum to specify where that personal property goes or to whom it goes. And so I think that's very important and maybe often overlooked, because I know some of that stuff maybe doesn't have a lot of monetary value, but oftentimes it has a lot of sentimental value. And I've seen a lot of people get a lot of hard feelings and even hire lawyers over some personal property. So we want to make sure that we avoid that if we can. So don't forget addressing your personal property in your estate plan. And you can see how this trust too does split into what we refer to as a marital trust and a family trust. And so that's really just two buckets of your assets. And the family trust is funded with the first spouse to die with their exemption amount. So in today's dollars, that would be the first 13,610,000, and then anything over that would go to the marital trust. And generally, the surviving spouse has access to both of those buckets or both of those pots of money. It's just maybe where they want to spend the money first. And so, you know, we often counsel that you want to spend the money out of the marital trust first, since the family trust money is already passed through the estate tax system. And then you can see on the death of the second spouse, you can see that this trust sets up individual trusts for each of your kids. And those trusts can have different terms if you want. Perhaps those trusts all have the same terms. You know, some kids maybe have different need protection from themselves. And so you can design those trusts differently. David, Bill, any thoughts on this diagram?
I would just say don't underestimate the significance of how that's set up, because, you know, I mean, you can get into different variations with like estate, you know, equalization. You know, maybe you're a physician and you own several clinics, and you have a child that's going into medicine as well. And so you have some kind of a succession plan for them to take over the ownership of the clinics. And you have, you know, two other children maybe that have zero interest in medicine whatsoever or owning a clinic. Well, how do you equalize that? Well, through proper estate planning, you can actually do that estate equalization and plan properly. So that way each child, each beneficiary feels equally valued, and not undervalued simply because they didn't choose medicine as what they wanted to do as a career. So.
And I think another situation where your kids are kind of at different stages of their life, where you have the younger ones you're still providing financial support to. So maybe the older ones have, you've helped get through college, graduate school, and help with their marriage and maybe buying their first house. But the younger ones maybe haven't gotten that far along. So at the end of the day, you may need to have that estate, go into what's called sometimes called a common trust. Until those younger kids have a chance to have been able to be equally benefited that the older kids had before it splits into the separate trusts. So sometimes that's more common. That's you see that more often in a family that has children where the parents are still providing that financial support, at least to the younger ones.
That's good. That's good. That's a good point. One other point I might just mention about these children's trusts that you see at the very bottom. Those trusts can be set up too, where you can name the children to be a trustee of their own trust share at some point in time. And those children can even keep those assets in that trust. And those trusts, remember, have some good protections. They're protected from that child's creditors because they're irrevocable. And they're not subject to any type of divorce decree if your child unfortunately has to go through a divorce. So just something to think about there. We're going to talk a little bit about advanced estate planning. We won't spend too much time on this. And I know we're, Angie, how much longer do we have on here?
I think we're good.
We're good?
Okay.
Okay, so advanced estate planning. Let's just talk a little bit about the different tools that we use. I just kind of want to bring some of these up, and David, you and Bill might bring some of these or share some of your experiences with using some of these tools as well. I'll mention the first one and then let you guys kind of elaborate on the others if you want to. But just using it, not to still Bill's fire, but not to using an irrevocable life insurance trust is very important from a perspective of ensuring that the death benefit is not subject to estate tax. And I get the question a lot. They say, Todd, well, I thought a death benefit wasn't subject to income tax. And it's not subject to income tax, but it is subject to estate tax if it's not owned properly. And you have to make sure that that you don't personally own the life insurance policy. And that's why we often use an irrevocable life insurance trust if you have life insurance policies that have significant death benefits on them.
And those will come back into significant popularity here going into 2026 with the exemption going down to 5 million.
True.
And that's what I was going to say, because now you're going to have folks that are, kind of middle class even, that are going to be, the beneficiaries are going to be subjected to estate taxes simply because they had a large life insurance policy. And
right.
So, these ILITs or irrevocable life insurance trusts are going to become very, very popular again as that estate tax sunsets. So incredibly important because, like you said, by law, by definition, death benefits are not taxable. But the government can find ways to tax it, and they will, right? With the estate tax. It's just, it's an indirect way to tax death benefit for the wealthy. But very simple process to be able to have an ILIT own it.
Yeah, and that's something that everyone on the call that you might look at if you have significant life insurance policies. And as David mentioned, with the exemption amount set to go down in January of 2026, it might be worth reviewing to see if you need to utilize an irrevocable life insurance trust. Bill, David, do you guys have any other comments you want to make about dynasty trust or charitable trust, limited partnerships? I know that's a lot.
Yeah, the uncertainty that happens whenever a trust comes to its end, and you don't always know, how that generation that's going to receive that money is going to handle it. The spending habits, of people that have received large inheritance in in life insurance proceeds. Research shows that the spending habits are no different than people that win the lottery. So in general, the money's gone in about 36 months. So a dynasty trust has the added ability to hang on to that and make sure that money is for the benefit of those future generations, but not subject to being completely depleted, just based on it going on into somebody who can't handle it. And it also is for estate tax purposes, because once you get it into the dynasty trust, it will continue to avoid the next generation's estate tax, which is called generation skipping transfer tax. But you continue to skip every generation's estate tax by having it in a dynasty trust. Otherwise, you have that 40% erosion that happens at the end of every generation. And if you want to be more like the Rothschild family versus the Vanderbilt family, the Rothschild family operates in their version of a dynasty trust, which is a perpetual trust.
That's good. That's good. Lots of things to think about there as you get into advanced estate planning, for sure. The charitable trust and the family foundation area, we could probably do an entire different webinar on that. So we might come back to that, but just kind of know that there are certain types of charitable remainder trusts and charitable lead trusts that can provide you with an income stream during your lifetime, with the balance going to a charity under a charitable remainder trust. And a charitable lead trust is just a little bit different, in the income goes to a charity with the remainder to a beneficiary. But maybe a neat way to create some income and some charitable deductions using that type of trust. And then, using limited partnerships and limited liability companies. As we mentioned here, there's some great opportunities for getting some discounts for both lack of marketability and lack of control. And that can be very helpful if you're trying to compress the value of your estate or minimize the estate tax that might be due on death of mom and dad. Using the limited partnership too, or the voting and non-voting shares in a limited liability company can be a very good way for you to stay in control of that entity and still give away some of the value. Dave and Bill, any thoughts there?
Yeah, the combination of limited LLCs and limited partnerships, also have the added benefit of asset protection planning, which is top of mind with a lot of our business owner clients and physician clients that have targets on their bullseyes on their chest. The charitable trust, what I oftentimes tell clients that have been very successful accumulating wealth is that they're philanthropists, whether they know it or not. At the end of the day, if they're above that exemption amount, they're going to be paying, that 40% of their estate to the government. And we know the government has a certain list of their charities that they like to give their money to. But on the other hand, you can disinherit that government using the charitable vehicles, which doesn't necessarily mean that all of that money goes to the charity, but it allows you to benefit from the charitable deduction rules to zero out an estate tax, but sharing some of that estate with the charity of your choice, and then that money, that wealth at the end of that trust then goes back to your family or to the dynasty trust. So it's a way basically to disinherit the government and also control who ultimately is getting those charitable dollars rather than the government.
That's good. Bill, any other thoughts there?
No, I mean, that's as folks do a really good job of building and growing their wealth, these advanced planning tools, these advanced estate planning tools they exist, right, to minimize to maximize control and minimize government involvement and via taxes, right? Like you said, you have the ability to zero out the estate tax and still be able to benefit your beneficiaries for generations to come. And so and oftentimes with these advanced estate plans, people are like, well, I don't know if I'm going to get there to where I would need this. But then they get there and because they only update their estate plan every 19.3 years, they forget to do it, right?
Yeah.
And so it makes sense to prepare early.
Well, yeah, and you know, one other thing I might mention that's not on here exactly, but is, you know, just setting up irrevocable trusts for the benefit of your kids, and you know, under those trusts, mom and dad can still be the trustee, and you can start using your annual exclusion amounts, which is, I believe, $18,000 this year, right? That you can gift away to each child. Dave, is that correct? 18,000?
You know what? I haven't had that question come up this year. So it was 17 last year. So I don't know if it went up to 18 or stayed at 17.
Okay.
It doesn't always go up every year.
Okay, but I guess the point is $17,000 or $18,000 a year that you could gift into these trusts, and I know that might not sound like a lot, but you know, over a period of years, that can really add up. You can get a lot of money out of your taxable estate just by using your annual exclusion amount.
Well, and when you add the spousal side of that, you know, doubles that per child. And if you use an LLC or a limited partnership interest where you can get a, you know, significant valuation discount, you can squeeze a lot more of that wealth that you're transferring if you do it via a limited partnership or an LLC, and you use both spouses' gift exemption.
Yeah, that's true. Very good point.
And as a side note, you know, on the limited liability and limited partnership, we also have an upcoming webinar on August the 7th that specifically is going to be addressing the topic of asset protection. So we'll be doing a deeper dive on the limited partnerships and LLCs on that webinar.
Very good. Well, I hope everyone can join us on that one. Invite your friends. We're going to go through an example fairly quickly on just of an advanced estate plan, so you guys can kind of see what that looks like. Whoops. So you can see in this advanced estate plan, we used a family limited partnership, and we have a 1% general partner here that's the revocable living trust, fully funded, right, guys? And then we have the limited partner, the 99% limited partner interest is owned by a dynasty trust. And you can see we also have a irrevocable life insurance trust. And so we're taking the life insurance out of the taxable estate. And by using this family limited partnership, we're utilizing what David mentioned on the squeeze and using the discounts for lack of marketability and lack of control, and also the freeze techniques to freeze the value of those assets. So we're really maximizing the amount of money that you can pass to your heirs without incurring a estate tax. And you can see your revocable living trust here has the marital share or the marital trust and the family trust. And as David mentioned before, the way to zero out or a technique that we like to use to zero out a taxable estate is what's called a testamentary charitable lead annuity trust. And so that's how we zero it out, and we let you pick your own charities instead of the IRS being your charity. So you can see how we have layered testamentary charitable lead trust, and those lead trusts pay to a family foundation that you would also control. I guess we could also use a donor advised fund there too, David, right?
Yeah, the benefit of a family foundation is you can keep the family members on payroll, and it gives them something to actively work on. Obviously, they could also be the donor advised fund advisors as well, but they wouldn't be able to be compensated by the donor advised fund versus if they had a family foundation.
Got you. So this is an example of an advanced estate plan. So Angie, do you want to cover next steps?
I'd love to. Thank you, Todd. That was a lot of really important information. Lots to think about. All right, let's talk about next steps. And again, thank you everybody for joining us today. I want to touch on our strategic wealth system model. These are essentially the building blocks when we partner with a client. These are all the areas where we want to work with you, having you equally strong in all of these areas, beginning with tax minimization, getting to a level where you feel like you have control of your money. And then lastly, and most important, and everything that we want to see in our life is financial independence. So with tax planning and working together, we hope to get you to financial independence. And then we always want to talk about David's awesome book, The Richest Doctor. Many of you have probably already read it, but if we can connect later, I would love to have a call with you and possibly send you that book so you can get even more information. Thank you, Todd. All right, so what does our process look like? So first off, if you have an introductory call with me, I would love to talk about what our process looks like in more depth. We start off with a strategic tax blueprint. That's where we will meet with you, develop a tax strategy, and show you where we can, save you significant amount of money. And if you move forward with us after your blueprint, we go into onboarding and implementation. There's a lot of things that are, roll into onboarding and implementation, which we would cover at a later date. But then lastly, and most importantly, year-end tax planning. That's where we're really going to show you all of, the fruits of our labor when we're doing tax planning. So you can see a lot of great cumulative tax savings with your tax planning. So as far as next steps on meeting with me, if you are new here and have not had a chance to speak with me, I welcome you to schedule a 30-minute introductory call with me. We can dive into, your current tax situation, kind of assess where we want to take you and what we can do for you and all the things that we offer with our unique tax planning model.
Great. Thank you, Angie. Did we have any questions from any of the participants? Or Bill or David, do you guys have any questions?
So while we're waiting for questions to come up, Todd, so tell us a little bit about how your estate planning practice is unique and what you focus on.
Sure. That's Dave. Thanks for asking. I mean, my practice is a little bit different. I mean, we try to really explain estate planning in terms that ordinary people can understand. I think sometimes lawyers are guilty of using making things very complicated to justify their fee. But we try to make estate planning simple, and we try to encourage everyone and make it a process that everyone feels like that they can go through and get their estate plan put in place. So I think we're different in that regard. And then we're different too in that we charge a fixed fee for your estate plan. So once we identify kind of what you and your family need to put in place to make sure you're protected in the event of a death or disability, we tell you what that fixed fee is up front, as opposed to maybe going into a normal law firm and them telling you that it's $400 an hour, and I don't know how many hours this is going to take. So we try to really just be upfront and honest with people, and hopefully that pays off and allows people to move forward implementing their estate plan.
Great, thank you. Angie, or Crystal, do we have any questions?
I do have a question from a viewer. Someone wants to know, what additional planning would you recommend as a physician's net worth increases?
Dave, you want to do that, or you want me to do that?
Well, how about we tag team? So I'd say, well, when you're right out of medical school and you got probably more student debt than you have assets, and you're not married, I'd say probably a will would be a good idea. And just owning everything and where your beneficiaries are named to whoever your other family members. But as you enter into life, major life events like marriage, children, acquire or buying real estate, having a retirement plan. All of those things that just add more complexity to your financial life, then I'd say at the beginning of those life events is when you should start thinking about a trust or revoke, and then make sure it's fully funded. I'm biased just because I have seen this happen so many times where people don't pay attention to keeping their trust updated. I think an annual review of their trust and making sure that they've got somebody coaching them on how to make sure everything's properly titled and in the name of the trust, and also other asset protection type of updates is probably needs to happen for a professional, a high income professional, probably at least once a year, no later than every 3 years, in my personal opinion, just because I've seen too many times where that problems happen between those time periods. And then as the estate grows, and depending on what the estate tax law is, it's been a political football, with Congress over the last couple of decades. When I first started, the estate tax exemption was $600,000. Of course, that was a long time ago, but you can, a lot more people were subject to estate tax than are right now, but that may change here in about a year and a half.
Mm-hmm. Yeah, that's good. And just like Dave said, I think as I just add to that, as your estate grows, I think the complexity grows, and there's lots of tools that you can implement. We covered several of them today, but looking at an irrevocable life insurance trust, exploring a charitable type of trust, a private foundation. There's lots of other tools that you can use as your net worth increases to make sure that you and your family aren't subject to the estate tax. The estate tax is kind of a voluntary tax, but you have to be proactive and implement some of this planning during your lifetime, or you're going to be subject to that tax.
Very good. We have another question. So they want to know, what are the proposed changes in the state tax exemption, and when are these changes scheduled to take effect?
Well, Todd had mentioned that, I think, earlier, but just real briefly, right now they're $13,610,000 exemptions. That's per individual. So a married couple is twice that. Those are scheduled to go back down under current law to $5 million on January 1st, 2026. That $5 million is going to be adjusted for inflation up through that time period. So we don't yet know what that adjustment will be. So that could be another, $1 million to $1.5 million, up to the $6 to $6.5 million. And again, this is something that has changed quite radically over my career. We even had, 14 years ago, we even had a year where we didn't have an estate tax. But anyway, that you just have to stay on top of you. Basically, my opinion is you have to have an estate plan that zeroes out your taxable estate, no matter what the exemption is at the end of your lifetime, so that in the event that you never get around to changing it, whatever the estate exemption is, you're going to minimize the estate tax in that year that you pass away, when that taxable event would have happened.
Yep, and that's what I was going to say, David. That's why it's, like you mentioned about annual reviews, because the estate tax laws are going to continue to change depending upon, over time and who's in office, who's not in office. It's a moving target, right? And so that's why it's so important to get the plan in place, so that, the plan is to zero out whatever that estate tax is. And then, again, if it's a moving target, you're still dramatically minimizing, even if they drop the amount a little bit more, right? And so it gives you the opportunity and the control to really pass more generational wealth where you want it to go, and prevent it from going to where you don't want it to go.
Yeah. Angie, any other questions?
We have one more, and this might be a little broad, but can you walk us through what documents you recommend for a physician who is just getting started? Maybe they have a house, checking and savings accounts, a retirement plan, a couple of cars, and a dog or a cat.
Well,
never forget about the animals. Don't forget about
the cat makes it way more complicated. But I would say without the cat, I think you've crossed that threshold of needing a revocable living trust. I think once you acquire real estate, once you have and you're not married, once you have a retirement plan, that adds enough complexity where at least you need a simple revocable living trust.
Mm-hmm. Yeah, I'd agree. And then just make sure you have all those ancillary documents, right? You want the pour over will, the durable power of attorney, healthcare power of attorney, and advance directive.
And as a side note, for those who don't know this already, but you can actually have a pet trust or a trust for your pet to take care of them if something were to happen to you.
Well, that's a fun fact. Didn't know that.
Yeah, Dave, did Jaja Gabor left a lot of money in her pet trust, right?
Yeah, she did. I think the only requirement is you have to have a human being, take care of them and receive whatever's left over at the end.
Right, right.
Noted. You all
Well, good.
have
I
any
think
questions?
I
I
think
think that's
we're-
all we have.
I think we've gone a full hour, so I would highly recommend everyone on this call, if you're interested, to join us on August the 7th, where we'll do a much deeper dive on the asset protection planning, which my experience is that's very top of mind, especially in today's litigious society. That we need to go above and beyond what a normal liability insurance can always can cover, and we also know that insurance companies are not always our friend. They're in the business of not paying claims if they don't have to. So sometimes you have to, once you get to a certain point, you need to do some things, taking things into your own account, and not totally relying on an insurance company to protect you. Well, great. Well, thanks everyone for joining us again, and we have another our third part next week. I think that is is it the 31st or is it
On Tuesday?
Oh, it's on Tuesday. Okay, sorry.
Yep.
So I think the invites for that is gone out. So that's where Bill's going to be talking about strategies to protect, minimize risk and protect your investments. So everyone, thanks again for joining us today, and we'll look forward to talking to you hopefully soon.
Thank you, everybody. We'll see you soon.
Thanks a lot.
Thanks.